Hello, and welcome to Williams Mullen Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets, as well as legal issues concerning digital advertising. I'm your host, Amber Duncan, and today I'll be joined by my colleague, Rob Van Arnam, a partner and chair of our IP section here at Williams Mullen, to discuss an advertising consumer topic, ADA claims and compliance related to websites and mobile applications. Rob focuses his practice on the licensing and litigation of IP rights and also counsels clients regarding privacy, data protection, promotion, and consumer laws. Hey, Rob, how are you doing today?
I'm good, Amber. Good to see you again.
Yeah, good to see you. Well, first of all, when I think of the Americans with Disabilities Act or the ADA, I think of physical barriers to those with disabilities. How does the ADA apply to websites?
Yeah, so the ADA's previous focus on physical barriers has shifted or expanded to websites and whether they are accessible, usually to customers who are blind or visually impaired. The claims are that the websites are places of public accommodation, and any access barriers like websites without screen reading software capabilities deny plaintiffs the right of equal access. Plaintiffs also have challenged the accessibility of mobile applications and online job applications as well. And this all came about in part because there was no final rule from the Department of Justice that set forth what compliance you had to do to meet the ADA. And in 2017, DOJ formally withdrew its notice of proposed rulemaking. And so there was no hard and fast act or rule to follow.
Okay. Well, so in the absence of a rule governing this area, what has been the result and why should companies be aware of this?
Right. Well, first and foremost, of course, accessible sites are important in good business to serve actual and potential customers. You're not going to get or keep customers that can't access and use your sites. Unfortunately, the absence of a rule has led to thousands of lawsuits over the last several years, as certain plaintiffs' attorneys have turned this into a sort of a cottage industry. As an example, the total number of lawsuits filed in federal court in 2020 alleging that plaintiffs with a disability could not use websites because they were not coded or effective with screen readers, et cetera, was 2,523. And that's almost 300 more than in 2019. The biggest number was back in 2017 to 2018. But still, that's a huge number of lawsuits. And while the intention to make sites more accessible is certainly a noble goal, the suits are really burdensome and costly, particularly for small companies. First, website remediation can be costly. Just hiring someone or doing it yourself can be expensive. And the damages in these cases are nominal in terms of compensatory damages. But like other ADA cases, the damages are attorney's fees to bring the action. So they can add up, particularly if it's litigated over a period of time. Typically, these are filed in New York and California has its own state law act called the UNRRA Act that sort of mirrors ADA, but allows for penalties and statutory sort of damages under California law, $7,500, $4,000 under the UNRRA Civil Rights Act. And so recently there have been cases in California that have expanded that to companies that are doing business via their website that's accessible and available to California residents. So just because a company's not in California doesn't mean that California Act wouldn't apply. And for these cases, there are few upfront costs, so they're easy for plaintiffs to file, and it's relatively easy to establish standing as well. So it's become a big litigation problem and a burden, again, particularly for small companies. And efforts in Congress to limit or narrow these lawsuits or create higher standards have failed.
Thanks, Rob. Well, that's quite a risk that companies face. Do the courts in different jurisdictions treat these cases the same?
They do to a certain extent, but there is a circuit split. So the courts in the First, Second, and Seventh Circuit hold that any website can be a place of public accommodation. So the site in and of it themselves is sufficient. Courts in the Third, Sixth, and Ninth Circuit hold there must be a nexus between the website and an actual physical location. So connected to some store, retail, restaurant, etc. The 11th Circuit is the latest appellate court to issue a ruling in this area, and it builds on the decisions in the Third, Sixth, and Ninth. And the case there was Gill versus Winn-Dixie stores. And while the court acknowledged that there could be a claim for violation of the ADA, it couldn't show it in this case because the website wasn't really an intangible barrier. But that was the ruling was relatively narrow to the facts in that no goods or service could actually be purchased on the website. Right? This is a grocery store. So if you got a coupon or something online, you had to go to the store itself to use it. And the in-store purchase was the key differentiator. And that court was different from a Ninth Circuit case in Robles versus Domino's. Domino's Pizza, obviously, you can interact with the site, order your pizza, and they found that that was sufficient. The Fourth Circuit, so in the Mid-Atlantic where we're based, has had a couple of these cases. One, they dismissed a lawsuit by the plaintiff against the Department of Labor Federal Credit Union because the plaintiff wasn't actually a member, so couldn't actually take advantage of the site or the credit union offerings. And so because of that, they said there wasn't really an imminent threat of harm or inaccessibility, and that just because the person attempted to use a site wasn't sufficient.
With courts treating this issue differently, is there a standard that companies should use to determine if they're compliant?
Yes, absolutely. So the courts, even though they are mixed on some of their findings, have uniformly said that the Web Content Accessibility Guidelines, or WCAG, and those are established by the World Wide Web Consortium, an industry group, that those are the gold standards. And we now are on version 2.1 of them. And they go from sort of good, better, best from A to AAA. And essentially the principles of accessibility under WCAG and 2.1 are one, that it be perceivable. So users must be able to perceive the information presented on the site. As an example, so there are captions that are provided, or there may be audio that can be used. Second is that it's operable. Users are able to navigate through the site and use it, operate it. Needs to be understandable. They need to be able to understand the information as well as the operation of it. And it has to be robust, and that users have to be able to access the content as technologies advance. So it maybe that you had a compliance site a couple of years ago, but the content or changes to what you've done has made it now not accessible or compliant.
Really interesting. Thanks so much, Rob. Any final words and takeaway for folks?
Yeah, I think that, the overall thought here is that commerce has substantially shifted further away from brick and mortar. And that was particularly true during COVID, and I think will remain the case. So there's further demand for online shopping and services. So accessibility is important, can't be overlooked. So it's now more important for businesses to think about these issues and their legal risks and refine or develop a compliance plan. Couple of the takeaways, obviously, first and foremost, accessibility is good for business. You want your site to be available and accessible to all customers. Second is don't wait to, until you get sued or have a demand letter to start thinking about and upgrading your site. Proactive steps save you time and money in the long run. Also prepare for litigation. So if you are affecting change or communicating about your compliance efforts, it's best to to protect that in privilege so it's not waived. Get involved with counsel early. There's some low-hanging fruit, some easy things you can do to your site. Implement a policy. It's literally 2 or 3 sentences at the top of your site that talk about the importance and the site's emphasis on accessibility, and document compliance and stay in contact with counsel and good vendors. There's a number of people that are offering this service now, but some of them are a bit fly-by-night or are doing it in a way that doesn't ensure compliance. So those are the main things that I would leave folks with. This is not a problem that's going away, and unfortunately, litigation will probably continue. So it's something they should be thinking about.
Great. Thanks so much, Rob. That will wrap up our discussion on ADA compliance related to websites. I'd like to thank Rob Van Arnam for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening. Until next time.